Dear students, we are back. I'm looking at question 1.2 now. I don't have many points for you because the majority of you did well in terms of this question. However, there were some common mistakes that I will look at. So let's look at the question. The question says, advise essay Boulder and Onsets on whether it can be said that they acted with intention in the form of dolus directus, dolus indirectus, dolus eventualis. Now, these questions are very direct. Okay, they're asking you for three things, but in your answer there are other things that you need to respond to as well so that you can give a comprehensive answer. Okay, you can't answer a question on intention without looking at all the requirements of intention. Now the requirements of intention are the following: is there direction of will, and is there consciousness of wrongfulness? Is the direction of will, and is the consciousness of wrongfulness. Remember, if there's no consciousness of wrongfulness, then there is no intention. Okay, so this is what I always tell students. This is how you answer a question. Firstly, state the law. Secondly, explain the law. Thirdly, apply the law. Whether you state the law, explain the law, and apply the law one after the other, or you state the law, states all the law, and then in another part you explain the law, and then in another part you apply the law, whichever way is fine. Okay, so let's begin. Dolus directus. So you've stated the requirements. You're going to say dolus directus is the direct aim to cause an unlawful consequence. Is there a direct aim to cause the unlawful consequence in question? The unlawful consequence is intention. The unlawful consequence in question is the murder of the children or the death of the children. Is there direct intention to cause the death of the children? No, there's no direct intention to cause the death of their children. There's nothing in the fact that says that they wanted to do this. Second question, dolus indirectus. States what is dolus indirectus. Dolus indirectus is indirect intention. Okay, it exists where, although it's not the defendant's aim and object to bring about the death of the children or the unlawful consequences, the person sees it as a certainty and nevertheless continues with his or her unlawful conduct. Okay, let's answer this. Now, we've come to the conclusion that it was not the person's direct aim, it was not Asa Boulder and Onset's direct aim to cause the unlawful consequence, which is the death of the children. But did they foresee it as an inevitable consequence arising from the unlawful action? What is the unlawful action? It is drag racing and driving under the influence. Did they, at the time that they were drag racing and driving under the influence, foresee that their action may actually cause harm? It's not about whether a reasonable person would have foreseen. It's not about what they should have foreseen. We are simply asking, did Asa Boulder and Onsets foresee this consequence, the death of the children, arising from their driving unlawfully? And the answer is simply no. They did not foresee it, because in their mind, they were just thinking that they were going to be able to avoid the collision. They simply thought that the children would move out of the way, or they would be able to drive in such a manner that they would never hit the children. So the thoughts of hitting the children did not cross their mind. What does this tell us? It tells us that there was no dolus indirectus. Some of you say that there was no unlawful conduct to begin with, and therefore they could not have seen the consequence of hitting the children. No, there was an unlawful consequence to begin with. The unlawful consequence was driving under the influence of drugs and drag racing. Okay, let's move on. Dolus in eventualis refers to a situation where the defendant foresees the unlawful consequence as a reasonable possibility, but reconciles himself with the possibility and continues with her unlawful conduct. Okay, so let me just break this down again. Refers to a situation where the defendant foresees the unlawful consequence as a reasonable possibility, but reconciles herself with the possibility and continues with her unlawful conduct. So the unlawful conduct again here is driving under the influence, and drag racing. Did they foresee the unlawful consequence as a reasonable possibility? What is the unlawful consequence that is in question? The unlawful consequence that is in question is killing the children. Did they foresee this as a possibility? The answer is no. We are told in the facts that they did not at any point believe that they would actually hit the children. It's not about what they should have seen. It's not about what a reasonable person would have seen. It's about ASAP, Boulder, and Onset. And the answer to this question is that no, they did not foresee this as a possibility. And therefore, we don't even need to go to the second point of the question, which is, did they reconcile themselves with the possibility and continue with the unlawful conduct? Right? Because this is two-stage inquiry. And if your answer to the first one is no, then your answer to the second one will also be no. Because you can't reconcile yourself with the possibility that you did not even foresee. What do we mean by reconcile? By reconcile, it means taking into bargain, accepting that this actually might occur, and continuing with your action. Okay, so let's just um, assume that they had foreseen the possibility that they might injure the children. How would you answer the second part of this dolus eventualis? The second part would be answered in the negative. Why? Because they did not accept the possibility that they would hit children whilst driving under the influence and whilst drag racing. Why do I say that? Because if they had accepted that possibility, it means that they would have accepted the possibility of their own death as well. Because if they're driving at that speed whilst intoxicated, drag racing, it means that they could crash, and it means that they themselves could be injured and they themselves could die. But there's nothing in the facts that tells us that they would have accepted or took into bargain that consequence. There's nothing in the fact that says that they did not value their own lives. So these questions are answered in the negative, and even if we answer the first one in the affirmative, the second one would be answered in the negative. Now, we need authority for this as well. So there are two cases that I was looking for. I was looking for the case of Jub Jub, and I was looking for the case of S versus Humphrey. How are these cases important? The case of Jub Jub is important for the following respects. One, the facts. I've time and time again told you that if the scenario that you are given relates to another case with similar facts, give me those facts. Okay, so you got a mark for that. You also got a mark for telling me what the case of Jub Jub held. Right? The case of Jub Jub said that intention is a subjective inquiry. There's a mark for that. It's a subjective inquiry because you're telling the examiner or whoever or the judge that you need to look at the subjective circumstances of the people involved. Okay, you needed to do that. Secondly, you needed to tell me how the courts decided the matter. The court simply said that once the trial court had decided the matter, they had decided that the drugs caused a sense of euphoria and led them to believe that no accidents would result, then what it means is that they did not foresee an accident. And even if they had foreseen an accident, they would not have reconciled themselves with the possibility. That's the first one. The second one, S versus Humphrey. In the case of S versus Humphrey, the facts are not important, but what the court said is that Humphrey had foreseen the possibility of his action causing harm to another, right? This had gone through his mind. The second question is, did he reconcile himself with the possibility? And the answer is no. He did not reconcile himself with the possibility. He did not accept the consequence of the train colliding with a minibus as something that will happen. He believed that although it's something that could happen, he believed that he would be able to pass through because he had done this a number of times. Because if we were to say that he had reconciled himself with the possibility, we'd be saying that he accepted that he himself would be injured from the accidents and that he could lose his own life. And there's nothing in the facts that tells us, in terms of that case, that he did not value his own life. Okay, so dolus eventualis is also eliminated. Then you need to conclude. You need to say that there's no intention in the form of dolus directus, dolus eventualis, and dolus indirects. You also need to say that there is consciousness of wrongfulness. There is consciousness of wrongfulness because these people are adults, obviously, and they are conscious about the fact that their conduct is wrongful. Okay, so one of the elements of intention is not met, which is direction of will. Consciousness of wrongfulness is met. However, you need to meet both these in order for there to be intention. And you're going to conclude that there is no intention. So that's your answer for question 1.2. I will discuss 1.3 at a later stage.